The outcome of the 2016 presidential election was shocking to many people for assorted reasons, including that former Secretary of State Hillary Clinton won the popular vote by 3 million, while Donald Trump won based on the Electoral College votes. The Supreme Court has just handed down a decision that makes that less likely to happen again, yet it still could. The High Court ruled unanimously on Monday that a state may require the presidential electors to support the winner of its popular vote. The ruling adds that the state may punish or replace electoral voters who don't follow that rule. Justice Elena Kagan wrote the opinion for what is described as faithless electors and whether the Constitution recognizes the electoral voters as representatives of the intent of their state voters or as independent voters. Specifically, at issue here is a Washington state law that Kagan wrote, reflects a tradition more than 2 centuries old. She added that in that practice, electors are not free agents, they are to vote for the candidate whom the state's voters have chosen. In the opinion, Kagan said, the state instructs its electors that they have no ground for reversing the vote of millions of its citizens. That direction accords with the Constitution as well as with the trust of a nation that here, we the people rule. While one lower court said the Constitution sees the electors as free to vote their consciences without fear of punishment or removal, the other ruled differently. The case didn't favor one political party over the other, leading to the Supreme Court's nearly unanimous decision. Justice Clarence Thomas disagreed with the majority's reasons but not the ultimate outcome. Both red and blue states had a stake in the case. They feared a few independent members of the Electoral College would ultimately decide the next president. That possibility is not completely eliminated. Not all states require conformity, and the opinion does not require them to set up a system to conform. Additionally, not all scenarios are covered. The 2 cases being considered were from Washington and Colorado. Washington had moved to fine Peter Brett Kayavalo and 2 others after they voted for former Secretary of State Colin Powell in 2016. They had pledged to vote for Clinton, who won the state's popular vote. In Colorado, the state replaced Michael Baca after he announced his intention to vote for then Ohio Governor John Kasich, R., instead of Clinton, who won that state as well. Baca was part of a group trying to deny Trump the presidency. Of 2016, the court noted that only 7 electors across the nation cast faithless votes, the most in a century, but well short of the goal. The Washington Supreme Court ruled for the state, explaining the Constitution's directive that gives states the power to select electoral college members also means they can set the standards they must follow. If they wanted to require them to honor their pledge to vote for the popular vote winner, they could. A U.S. Court of Appeals for the 10th Circuit panel had a different opinion. It felt the state's control ended with deciding how electors would be chosen. It argued that after that, the Constitution gave the electors the freedom to vote the way they wished to. 32 states, and the district, require electors to pledge their support to the state's winner. Most expect electors to honor the popular vote, as the electors are chosen by the winner's party. 15 have penalties for punishing or replacing electors who break their vow or change their minds. Kagan noted that history shows a number of votes cast by rogue electors were counted, yet none even came close to affecting the election. She said both history and the bare-bones instructions in the Constitution are in favor of state restrictions. While the electors in question in the court cases believed the Constitution required them to have the freedom of choice, Kagan brought up Alexander Hamilton, saying that in the Federalist Papers, he praised the Constitution for entrusting the presidency to men most capable of analyzing the qualities needed for the office, who would make their choices under circumstances favorable to deliberation. She added that even assuming other framers shared that outlook, it would not be enough. Whether by choice or accident, the framers did not reduce their thoughts about electors' discretion to the printed page. Representing those believing in the independence of electors, Harvard law professor Lawrence Lessig said in a statement, "When we launched these cases, we did it because regardless of the outcome, it was critical to resolve this question before it created a constitutional crisis." Obviously, he added, we don't believe the court has interpreted the Constitution correctly. But we are happy that we have achieved our primary objective. This uncertainty has been removed. That is progress. Still, this would not change the results of the 2016 election, had these rules been in place. Arguably, however, the popular vote could have been different if voters knew how their vote could be interpreted or thrown out by the electoral voters. What this decision says, though, is if states want to, they can require the electoral voters to vote for the popular vote winner. All that's left now is to decide whether Trump will win the national vote or whether it will the presumptive Democratic candidate, Joe Biden.